How about first, whether is it irrelevant or not?
Yes, if there's no other independent state interest that meets the rational basis interest. Marital rape exemption existed in history for hundreds and hundreds of years. For hundreds of years, it was okay for a man to rape his wife. And this court did not hesitate for a second to say that that did not meet the rational basis test, despite at the time the fact that 40 other states had marital rape exemptions. The same thing is true for consensual sodomy. Again, it seems funny today, but I think we can all agree that at the time that this court decided Onofre in 1980, it was a long-standing, multi-century tradition from the beginning of time, as I think has been said earlier, to criminalize consensual sodomy between consenting adults. Most states at the time did, and the Supreme Court 6 years later said it was okay, which goes to the question of how the equal protection clauses are interpreted differently by the federal courts and by this court. Again, this court didn't hesitate to say that despite that tradition, it was unconstitutional and did not meet rational basis, given the reasons that were proffered to have a criminal statute that prohibited consensual sodomy and had a marital exemption. Let me talk about the Brown case. You asked a question about the Brown case, and you said, wasn't the result in the Brown case moral? Of course it was. But the issue here is whether moral disapproval standing alone is sufficient. In Brown, there were a host of other reasons that compelled the court's result, including the fact that it was clearly good public policy to eliminate separate but equal schools. Again, there is no good public policy that has been offered by the city, by the state, or even by amici for why my clients and these appellants should be denied the rights to marriage. Let me talk about the different standard. It is true that in the Dorsey case and the cases that followed it, this court has said that with respect to the state action requirement, the federal constitution and the state constitution are equivalent. I want to say a couple things about that. First of all, let's talk about the Dorsey case for a second. It was decided in the late 1940s. It upheld segregation at Stuyvesant Town. That's what the case did. I would respectfully submit to your honors that if this court were to hear the Dorsey case again today, it would not rule that way. In addition, the Dorsey case was decided before PJ Video. PJ Video says that in order to decide whether any aspect of the state constitution gets interpreted more broadly, you looked at the distinct culture, history, and tradition of the state. This court has said many times that with respect to due process, even though the language is identical, basically identical, this court interprets due process more broadly because of the distinctive history, culture, and tradition of New York State. I would respectfully submit to your honors that there is no difference in the culture, history, or tradition of New York between protections of due process and the protections of equal protection. In addition to that, with respect to the way this court conducts rational basis review, I said earlier that I didn't want to put words into your mouth about what you do, but there's absolutely no doubt that when you're doing rational basis in cases like these, you look at the exclusion. Let me quote Judge Simons in the McMinn case. He couldn't have been more clear about this. He said, by limiting occupancy of single-family homes to persons related by blood, the Oyster Bay Ordinance impermissibly excluded, his words, excluded many households who pose no threat to the goal of preserving the character of the traditional single-family neighborhood. Again, the same logic applies here. There is nothing about excluding my clients and these appellants, many of whom are sitting in this room, from the benefits of marriage that does anything to help procreation, to help stable families, or do any public interest that's been asserted by the city or by the state. Judge Smith, you asked a question about this.
Does the exclusion have to have a benefit, or is it enough to show that the exclusion does not offer the same, that the excluded class does not advance the goals of the legislation to the same degree? Wouldn't that be a rational basis?
You have to conclude that the excluded class advances the goals of the legislation. The goal of the legislation that's been proffered here is having stable families for children. There is nothing about excluding the class here that in any way furthers that interest.
Well, my question is, does it have to further the interest? If it does not, obviously there's a certain cost to the institution of marriage. People who are married get a lot of benefits, which are all over your briefs, and the rest of the public pays for them.
Right.
do we have to extend those benefits to another class if the legislature could reasonably conclude that the benefits are not offered to the same degree by including that class in the group?
Well, cost, the legislature cannot consider. If you look at what the court said in Romer, the justification in the Romer case was simply cost. Gays and lesbians shouldn't have rights in Colorado because it would be more costly for them to have the rights. And the Supreme Court made it really clear that cost alone is insufficient. What was really
what I was really asking was whether, in deciding for whom to incur these costs, can the legislature not consider the extent to which the objectives of the legislation will be advanced? That is, does the excluded class, does including the excluded class actually have to harm the objectives, or did you just say that it does not advance them as much?
I have to tell you, McMinn, Judge Smith, I don't think there were a lot of families in Oyster Bay that wanted to live in these homes where it was, there was no statistical evidence of how many single people or couples who were unmarried wanted to live in these homes. And that didn't hesitate for a second in preventing Judge Simons from saying to McMinn that the under-inclusion and that the fact that the exclusion didn't meet the interest failed rational basis. There's not a statistical requirement under this case's precedents. And surely I think we can all agree that 46,000, more than 46,000 families is not an insignificant number. With respect to Judge Smith's two real quick things, his question about the studies, that is cited in our brief. There's a footnote 64 on page 34 of our brief. The American Psychological Association's brief. There are a number of studies cited there. If you want to read just one of them, Judge Smith, I would commend the first one cited. And I would point out on that fact that even James Q. Wilson, who submitted the amicus brief on the other side, even Professor Wilson concedes that there's absolutely no studies that show that there's any harm to children from being raised in gay and lesbian families.
Who has the burden of proof on that issue?
What?
Who has the burden on that issue? That is,
we have the burden, but I think we've met the burden. And let me go to the final point. And the final point has to do with respect to this question of incrementalism. And I understand basically the arguments that have been made by the other side is that you should allow the legislature to experiment here. What I would submit to your honors is that given the hundreds of protections and issues that are afforded to people based on marriage, given the rights and protections that are afforded to at least those 46,000 families, to allow the New York State legislature to do it piecemeal, where it could be decades and decades before those children and those families have the full rights and protections that the family across the street has, is not consistent with this court's jurisprudence. Thank you.
Thank you, Ms. Campbell.
All please rise.
Massachusetts is the only state that currently allows gay couples to marry. This is part 2 of the oral argument in 4 New York same-sex marriage cases. You can watch part 1 with attorneys arguing for gay marriage at cspan.org. Just click on America and the Courts. And join us next week for America and the Courts, Saturday evenings at 7 p.m. Eastern on C-SPAN.
The House this week passed a non-binding resolution on the Iraq War, 256 to 153. It declares that it's not in the national interest to set a date for troop withdrawal, and that the U.S. will prevail in the war on terror. 42 Democrats joined 214 Republicans voting for the resolution. The House is back for legislative business Monday. Next week's agenda includes defense spending, a bill giving the president a modified line-item veto, and reauthorization of the Voting Rights Act. The House is live on C-SPAN. And the Senate returns Monday to continue work on the defense authorization bill. The U.S. Senate's live on C-SPAN.